Good morning, ladies and gentlemen. For those of you here at the Savoy Hotel in London, and for those of you joining online, and I think we have over 140 people around the world tuning in today, so we've got a sizable virtual audience as well joining here. So first of all, welcome to this seminar, which is being jointly hosted by BIMCO and the London Shipping Law Centre. Now, today on stage, I have 4 members of the drafting team who put together SHIPSALE. I'm just going to introduce them. We have Matt Hannaford from Hannaford Turner Law Firm in London. John Varley from Arrow Shipbroking, Christoph Bruhn from the Hamburg shipbroking firm, Bruhn Shipbrokers, I think that's right. And then last but certainly not least, Sarre from CMB in Belgium, who's actually the chairman of this particular project team. So they're all here to explain a little bit about the project. Also on the stage here, we have my colleague, Casper Broustbo from BIMCO. His task here today is to drive SmartCon. So what we thought we'd do in order to help illustrate this new contract is to actually put it on the screen for you and work through a few examples so you can see how it actually works in practice. It is a modern document, so it's a digital document, so it does things in SmartCon that you don't actually happen in paper, so I think it's really important that you understand and see how things will actually work out in practice. My name is Grant Hunter. I'm from the BIMCO Secretariat. I was very fortunate to get to work with these 4 gentlemen and the 6 other members of the subcommittee. I think that some of these are joining online today as well. In the 2 years it took to develop the SHIPSALE agreement. It was quite a challenging task, made even more challenging by the pandemic, meaning that quite often we had to meet online. Occasionally we did get to meet, and I think it's quite remarkable that they've managed to produce a first-class product, basically based on the fact that we just gave them a couple of hot meals and lots of hot coffee during the process. But they worked very hard through this. They worked online. They're a really, really dedicated team, and I think they've actually produced an excellent contract. Now, part of the process that BIMCO uses when developing these contracts, of course, it's one thing for the drafting team to come up with their ideas, but we need to engage with the industry as well. So a very important part of this process was a consultation exercise where we went out to the industry and we showed them quite an advanced draft of what we produced and got their feedback. And we actually had feedback from over 200 companies and individuals, and I think there was something like over 800, maybe 853 individual comments that we processed. But it's a very important part of this because we wanted the industry to make sure that they have buy-in to this, that they're hearing their views, what they consider to be a good contract. And that was a very, very important part of the process. It took a long time to process all these comments, but it just shows it's a very, very thorough process that we go through here when we're developing a contract by BIMCO. I think the end result is a very good, it's a modern and comprehensive and relevant new SHIPSALE agreement. I think from my point of view, I've just got a very simple message for you. That SHIPSALE 22 is a better document than whatever SHIPSALE agreement you're using at the moment. And the purpose of this seminar here today is to ask these gentlemen to explain why that is. So we're going to start off with Matt, who's going to run you through the contract. We'll just go each of the clauses, just give you a guiding sort of note as to how the contract's actually structured and how it works. And then we're going to dig a little bit deeper into each of the clauses as we go along. In terms of questions, we can take questions for those of you online if you tap something into the chat section, and other than that, we'll take questions from the audience. If you can let Matt do his first run through first, and then as we go into the various clauses, you're free to sort of chip in with questions as we go along. And at the end, we'll also have a Q&A session as well. So let me hand you over to Matt.
Thank you, Grant. So, as Grant said, I've got the pleasure of walking you through the SHIPSALE 22. It's going to be a very quick canter through. I'm not going to linger on the clauses, just a few highlights of each clause. The point being to give you an idea of the structure of the document and a little bit of familiarity. As we go along, for certain clauses, as Grant also said, Casper is going to help me show how we can complete and amend SHIPSALE 22. So hopefully there'll be a bit of an interactive element to it as well. So to start with, let's talk about the structure. We have 2 parts to SHIPSALE 22. Part 1, which is the box format, and part 2, which contains the standard terms and conditions. There are also some annexes at the back, which we'll come to when we get to that point. So part one is a box format. Most people who use BIMCO forms will be familiar with the box format. The idea is that parties can see the key terms of the transaction at a glance. So to start with, let's start this interactive element, Casper. So let's just put in a few things just to get an illustrative example about how it works. So we're going to call the vessel for the purposes of this seminar, MV BIMCO Voyager. And let's assume that the date of the agreement is today's date, it's the 18th of May. We've prepared it. So let's do that. Now, the next thing I just wanted to talk about was guarantors. You'll see at boxes 5 and 6 that SHIPSALE 22 contemplates the possibility that the obligations of the buyer and the seller may be guaranteed. So if that's the case, then you can see that boxes 5 and 6 ask for the parties to fill in the name and address of those guarantors. And later at the bottom of the boxes, if you go down, Casper, to the signature part, you'll see that the guarantors can also sign the guarantee, the SHIPSALE 22, and bind themselves to it. Alternatively, as we know, it is frequent where guarantees are in place that rather than just simply signing up to the guarantee by virtue of their signature to this form, the guarantee will be a separate instrument, in which case the names and details of the guarantors will go into box 5 and 6, or as applicable, but then the signing would be actually on a separate guarantee instrument. As we know, more often than not, there aren't any guarantors for these types of agreements. Again, just for illustrative purposes, it's always best practice, whether in this contract or any other, when the box is not to leave them blank, but actually to fill them in. So here in boxes 5 and 6, Casper, let's put not applicable or NA to make it absolutely clear that the intention of the parties is that there's no guarantors. The final thing I'll do for a bit of completion of this is just to talk right to the bottom down to clause 24. It says here numbers of any additional clauses. It says numbers rather than number. So what you would hear if we had, for example, 3 additional clauses, there are 27 standard clauses in the printed terms. So if we had 3 additional clauses, what we would insert here is 28 to 30 inclusive. Thank you. So that's your part 1. I would say the last comment I'd make on the boxes is at the bottom, underneath directly. There we are. We've got, here we go. If you look at where it says authentic BIMCO template, you'll see that there is a confirmation that if there is a conflict between the terms of part 1 and the terms of part 2, it's the terms of part 1 which will prevail in the event of a conflict. So we'll come back to fill in some more boxes a little bit later as we go along, but let's now move into part 2 of the standard terms. So the first clause is a fairly comprehensive definitions and interpretation clause. If we go down to the bottom of that clause, Casper, you'll see that B, C, and D. In D, it also confirms that capitalized terms used in the boxes will also be defined terms when they're used throughout part 2 of the contract. I'm going to take this opportunity also to show now how we amend the form by using the example of delivery documents. So here, if you look at the definition of delivery documents, you'll see that it's the documents that are listed in Annex A to the agreement. If we could go to Annex A very quickly. So Annex A, here we provide, SHIPSALE 22 provides a list. It's in 3 parts. Part 1 is the documents that the seller will provide at delivery. Part 2 is the documents that the buyer is required to provide at delivery. And there is a part 3 just confirming the protocol of delivery and acceptance to be signed in accordance with clause 16D, to where the parties confirm the time, date, and place that delivery and transfer of title takes place. So if we go back to that definition, Casper, as we know, it's common in SHIPSALE transactions for the parties not to use the list that's contained in the standard form, but rather to negotiate the list separately and include it in an addendum. So by way of showing how the form can be amended, here we need to make two amendments. The first is to amend the definition of delivery documents. So now we see that we've got delivery documents means the document set out in addendum 1 to this agreement. And then secondly, there would be then to delete the applicable parts of Annex A. So we would take out part 1, part 2, and if the protocol of delivery acceptance is being referred to and dealt with in the addendum, we would take out part 3. So that's hopefully very simple and straightforward and shows clearly how the amendments will look on the form. So if we go now to clause 2. So clause 2, sale and purchase. This is just telling us right up front what's included in the sale and not included in the sale. Obviously, we have the ship itself, but we've also got the concept of included items. I won't go through the definition, but essentially it's what's on board at the time of the inspection, or if there's no inspection, the date of the agreement, unless those items have been expressly excluded. So excluded items is Annex B. So Casper, if you could go to Annex B, and let's imagine for our illustrative example that we are going to exclude gas bottles. You've got the thing ready to put in there. So you would put those gas bottles, 12 gas bottles, and the video tell they're the examples commonly used. Once those have been placed in Annex B, the effect is that they are no longer part of the sale and the seller is not required to provide them or replace them at the time of delivery. If you don't put it in the excluded items list, then woe betide the seller, as they will then have obligations to provide or replace. Clause 3, please, Casper. So clause 3, we hope is a very useful feature. This is a subjects clause. As we all know, it is common for parties to sign the ship sale agreement on the basis that they do not intend it to become legally effective until one or more subjects have been lifted, conditions being satisfied. So how do we do this? So if Casper, you go to the subjects box in part 1. There we are in box 25. So let's, for our example, it's one of the most common subjects that need to be lifted before the parties want to enter into a binding contract is board approval. So for our example, we are going to have the buyer's approval of their board of directors. And as we'll see, the box 25 requires the parties also to put in a latest date for that subject to be lifted. So in this case, if we go back, that's that clause 2, 3, sorry. At that point, we'll see that those subjects need to be lifted by that date. If they're not lifted, the contract becomes null and void. Clause 4, purchase price. It gives its own clause, sets out what the purchase price is actually the sum payable for the vessel and the included items. And it also makes a confirmatory statement that while the bunkers, oils and greases are included in the sale, they are not included in the purchase price, and that will be determined in accordance with clause 13. I think as an overall point, I would say that here, by clause 4, we actually understand and we've got a whole structure of the deal. We know what's included, what's excluded, what the price is, and we also, at this point, know at what point the contract is intended to become effective. And this was very much part of the, if you like, the approach taken to follow a very logical sequence, as we'll now see as we go through the next set of clauses. So now we've got clause 5, which is the deposit clause, following the standard market position. I think that there is a new feature, which I believe, Francis, you'll be talking about, which we call the disruptive banking event clause. But I'll let Francis talk about that. So we've got our deposit, and then we move on to our before we go to the inspection, actually, let's do a couple more boxes just to fill it in. So let's look at the purchase price and let's call that $10 million. Okay, so that's going in there. And the deposit, well, let's, as we know, the usual fallback is 10%, not always these days, but let's use the most commonly adopted percentage for there. So there we've got that filled in there. Good. So if we can go back to the clauses. Thank you, Casper, you're keeping up very well. So now we've got the inspection. So here we've got, this is the initial inspection. There are three options. Either the most commonly adopted inspection regime is the pre-contractual inspection. So in other words, it's been done before the contract is signed. That's 6A. 6B is where the parties have agreed that the inspection will take place after the contract is signed, usually shortly after. And 6C, track down a little bit, is the circumstances where the parties have agreed to dispense with the initial inspection, classically because, for instance, the buyer may be a bareboat charterer who's been operating the vessel for some time and is familiar with it. So you have three choices. Let's see how it works, Casper, with the box, and I think this is box 8. So in our case, again, let's go with the most commonly chosen one, in this case 6A, the pre-contractual inspection. So you would select 6A, and then at this point, we would want to then, in accordance with the clause, set out when the inspection took place and where. And in this example, we've used, I think, the 30th of April, and the inspection took place in Singapore. So we're starting to see some shape to this document. Now, if we go to the next clause. So then 7, we've got the buyer's reps clause. The only comment I'll make on this is that we've pushed this right up to the front. So in logical sequence, obviously, we know that the buyer's reps entitlement to go on board the vessel is normally after the payment of the deposit. So we've placed this close to that soon after the deposit clause and the inspection clause in circumstances where there is a post-contractual inspection. Clause 8, now we're into the underwater inspection. The only comments I'll make on this, because I believe, Christoph, you'll be talking about this, is that clause 8 and clause 9, the dry docking clause, are separate clauses. So the only thing I'll do here is on the interactive basis is to show how this will work. So essentially, when we get to the boxes, box 17 asks the parties to determine and insert whether they want to go for the regime where the vessel is subject to a diver's inspection, and only if the diver's inspection results in damage affecting class of the underwater parts, will it then go into dry dock. In that case, you would select clause 8, and that regime will then take place. That's the one we'll do here. Obviously, in those less common circumstances where the vessel is going straight into dry dock, obviously you would then choose clause 9. So if we go back to the clauses again. So then we move now, we've had our inspection, underwater inspection, we've had our dry docking. These next clauses now are focusing and honing in on that key moment of delivery where we have movement for the physical handover and transfer of legal title in the vessel. So key clause is condition of the vessel at delivery. In SHIPSALE 22, we have effectively combined both the physical conditionality obligations and what I'll call the legal conditionality. So not only do we have all of those great things about the vessel being as she was, or it was at the time of inspection, free of average damage affecting class, but we've also, as we work up, got our legal warranties and indemnities in respect of claims and encumbrances. So on to clause 11. So now we're moving closer to the delivery point. This clause 11 is dedicated to delivery notices. So we have our usual pre-delivery notices, the narrowing window we get as the vessel gets closer to the delivery point, and then the notice of readiness where the vessel is at the place of delivery and the seller is ready in all respects with the vessel physically ready for delivery. The key feature here, we've got, again, part of the approach that SHIPSALE 22 takes is really to be very, very comprehensive in spelling out to the parties exactly where things are. Here's a good example in C that we have a complete list of all of the conditions that must be satisfied before NOR can be validly given. Clause 12, vessel delay. Only comment I'll make on that is that we have the link through to the fact that clause 19 will apply in the event that that the contract is terminated. So we'll get to clause 19 in a moment. Other than that, I think it follows the market standard practice. Bunkers, oils and greases. Again, this is going to be talked about by John. Are you talking about that one? So I'll pass on from that. But again, it's got its own clause. We've housed a number of these clauses, given them dedicated clauses rather than mixing and matching. So there's an example of that. Clause 14, payments. Okay, again, we've given a payments its own dedicated clause. I don't think there's anything particular for us to say on that one, apart from we can work it through. But it then spells out the usual. Obviously here, there is an assumption that the deposit, as well as being acting as security for the performance of the buyer's obligations, it's also, as is common, acts as part payment of the price. So the deposit will be released and the buyer will be obliged then to remit the balance and all other sums that are due at delivery. Delivery documents, we've spoken about delivery documents. Here it's a two-part clause. Again, we've given it its own clause. The first part talks about the timing for exchanging copies, drafts and samples. And the second clause at 15b talks about what one does if those documents are not in the English language. So we've moved up in these clauses right up to the moment, and now we've got to that key moment of delivery. So here we have a delivery clause talking about the process where physical possession and legal transfer will take place. Clause 17, again, another effectively dedicated clause giving some obligations for both the seller and the buyer post-delivery. We then have our seller's termination rights. So obviously, the main thing being if the buyer either fails to pay the deposit within the specified time or, having paid the deposit, fails to take delivery and pay for the vessel within the specified time. And then obviously at 19, we have the reciprocal clause for the buyer's termination rights if the seller fails to be ready to give notice of readiness by the cancelling date or is not ready to validly complete a legal transfer by the cancelling date. Clause 20, total loss, standard clause. If the vessel suffers a total loss before delivery, then if there's been a deposit has been paid, it will be returned and thereafter the contract will be null and void. 21, we have, we think, an interesting new feature showing hopefully the modern nature of this document. As we all know now, it is absolutely standard to have these regulatory style clauses in. So 21 and 22 is sanctions and anti-corruption, and Francis will be making some observations on those clauses. We've also included a confidentiality clause. This was something that was from the sounding board that Grant talked about. We had a lot of comments asking that for a confidentiality clause to be included, but the overwhelming response from the sounding board was that while it was important to have a confidentiality clause, a breach of confidentiality should not enable the innocent party to terminate the contract. So that's the style. It may well be that there are circumstances where parties wish to amend that to create firmer obligations, but that is what the standard printed terms say in SHIPSALE 22. 24, notices and communications. So here, the parties are invited to insert the contact details in boxes 21 and 22. The one comment I would make for this is there is an exception that where notices or communications are being given in respect of arbitration proceedings, there is a separate notices provision within the law and arbitration clause, and I'll come to that when we get to the final clause. So then we have our entire agreement clause. This now familiar, we understand that the basic principle being that the contract represents the entire agreement of the parties. It's a comprehensive clause, both to deal with representations that are made prior to the contract and also to disapply statutory implied terms in both cases to the extent permitted by law. Let's now go to the law and arbitration clause. So I think the best way to describe this, the default position under SHIPSALE 22, the default position, is that the agreement will be governed by English law and London arbitration, LMAA. And as we can see, that's how it's set out here. However, through the magic of SmartCon, there are a number of options that the parties can choose if they do not want English law to apply. So we go to our boxes, and we go to box 26. And when you drop down your options, you'll see that there are 1, 2, 3, 4, 5, 6, well, 7 if you include other. So there is the option for English law, US law, Singapore arbitration, Hong Kong arbitration. So if you wish one of these, you select it. Let's go for US law, Casper. Once you've plugged that in and saved it, the magic of SmartCon then works. And if we return to our clause 26 or clause 27, 26, you'll see that by saving that option for US law, the clause has automatically changed. And now we've got the New York arbitration clause included. And in each case, there will be opportunity for small or intermediate claims where the size of the claim and the counterclaim do not merit a full arbitration. So I think that's a useful feature. I think it's easy to use. You make it look easy to use, Casper, but I think it is. It's intuitive and it's good. So we get to the final clause. Again, I think, Francis, are you talking about the electronics clause? Yes, you're going to talk about this, so I don't think. But so all I will say on that one is, again, we're all finding, not just with SHIPSALE, but with all our contracts, that more and more electronic signatures are being used. Again, I hope this is a good feature for the contract, not just for today, but moving forward. Thank you very much. You up? Right. I shall introduce John Varley.
Thank you, Matt. Having been a sale and purchase broker for quite a few years, I'm fully aware that the sales form is not necessarily a priority in the working day for a broker. I know that many times in a competitive situation that we often have to persuade a buyer to agree seller's issued terms and sometimes pick up the pieces later. But that doesn't detract from the importance of having a standard sale form that we can use as a basis for sale and purchase. A form that is hopefully logical and fair to both sides, a form which is hopefully up to date, and already includes clauses which we often have to incorporate later into MOAs. And therefore, hopefully, the transformation between recap of terms to signed MOA does not require lengthy delays and renegotiations. A few illustrations where we have a fresh approach, and there might be an element of repetition from Matt here, but and or additional clauses. If we turn to clause 3, the subjects clause, which is a new additional clause. It is not unusual when dealing with clients that subjects to the deal are required. quoted companies, corporations, tenders, state-related entities may require internal approval before proceeding with a deal. So the type of subjects would commonly be sellers or buyers board approval, which may relate to financing or finding suitable employment. Here we give allowance for both buyers and sellers subjects to be listed in box 25 of part 1 of the sales form, with a clear state subjects, if any, and latest date with which subjects must be lifted. Obviously, if this is left blank, then there are no applicable subjects. Clause clearly states that if subjects are not lifted by and within this date, then the contract shall be null and void, and neither party shall have any claim against the other party, and both parties shall immediately be relieved of any obligations and liabilities to the other party under or in connection with this agreement. If the parties are not contracting under English law, they should check with the relevant jurisdiction, as other jurisdictions may determine there is a binding agreement even when all subjects have not been lifted. However, clause 23, confidentiality, and 26, law and arbitration, shall survive this agreement, i.e. they shall remain in place and adhered to. And clause 13, bunkers, oils, and greases. In other sales forms, the bunkers clause is lumped in with spares and other items. In the SHIPSALE 22 form, it is given a distinct and separate clause. The first and important differential is the requirement prior to delivery, there shall be a joint survey by the parties to establish the quantities of the bunkers, oil, and greases. Of course, this is logical and in most cases normal standard practice, but it is often not stated, but we hope it is seen as an important and useful addition. Of course, this doesn't take into consideration the difference in quantities between the time of the survey and the time of delivery. Any consumption should be accounted for in the final calculations. To avoid any misunderstandings, the definitions of parties, being the sellers and buyers, is covered under definitions and interpretation under clause 1, as are bunkers, being bunkers on board. The vessel at delivery, and oils and greases means unused lubricating, hydraulic, and thermal oils, unused greases in the vessel's designated storage tanks, and in unopened drums, cans, or containers on board the vessel at delivery. Again, after consultation, we've gone into a little bit more detail, incorporating hydraulic and thermal oils. In other forms, this clause is worded in such a way that inevitably the clause has to be redrafted for the executed document, i.e. bunkers and lube oil prices are linked together. In the SHIPSALE 22 form, the two are separated, i.e. B for bunkers and C for oils and greases. With respect to bunker price evidence, as well as invoices and vouchers, we've also included charter party statement of accounts. We're aware that in many instances, the relevant bunker prices are back-to-back with redelivery from a charter. And therefore, the relevant bunker prices should be evidenced by a charter party statement of accounts. The reference to prices in plural is to ensure that sellers do not apply one price in circumstances where they pay different prices for different amounts. We've also used the word latest instead of current, which we believe is more appropriate and not ambiguous. We have used excluding barging expenses with relevance to bunkers, and excluding delivery costs with relevance to lube oils, which we believe is also more relevant. The agreed alternative is selected in 18, box 18, with a provision that in the unlikely scenario it is left blank, and 13B1 and 13C1 shall apply, that is net prices paid by the sellers as evidenced. If, of course, specific prices are agreed during the negotiation, these can simply be inserted in box 18. Then we have clause 23, confidentiality. Again, some form of confidentiality clause is inevitably included in an MOA. And here we have drafted what we believe should cover most eventualities. In our clause, we've taken into account that if required by law or stock exchange authority, or indeed to perform some obligations under the agreement, it may be necessary to use some form of the contents of the agreement. but it must always be treated confidentially. Of course, in the vast majority of sales, a breach of confidentiality should not be considered as a route to terminate the deal. And hence, in our clause, a breach should not give either party the right to terminate this agreement, but confidentiality is considered by most to be important. However, speaking as a sell and purchase broker, I've always found confidentiality clause somewhat at odds with the workings of the sell and purchase market. The sell and purchase market, as most of you know, works on precedent. The price achieved on the sale of one vessel sets the market for the sale of the next comparable vessel. Market reports are produced daily and weekly, and the information in respect to prices achieved, which rarely completely verified, is used to set the market. If no sales information leaked, there'd be no market. On the other hand, buyers and sellers rarely wish information to come into the market, so it is important to include confidentiality clause, which may prevent premature leakage of such information. The identity of the actual buyer may be particularly sensitive. Often buyers do not wish to be known to be in the market, or sellers may not wish the market to know they're selling. A confidentiality clause often ensures accurate information about a sale is not reported and delays the reporting of a sale. But on the other hand, it is almost inevitable that a sale is reported at some point, but the actual details may well remain confidential. But as mentioned earlier, it is vitally important in the vast majority of sales that the parties cannot terminate the agreement due to a breach of confidentiality. Otherwise, it could be certainly misused to frustrate a deal. Christoph?
Yes, a warm welcome also from my side. Good morning, and thanks for your attendance here and of course also online. Like John, I'm coming from the practical side. I'm an S&P broker since many years, and so we are focusing our work in this group on the practical issues and the situations that we have to deal with in most of the cases during the negotiations in order to guide our clients into a good contract, as John correctly said, but also then being safe for special situations when they occur prior to delivery. So this is why my little baby is the underwater inspection since many years. And I want to highlight a few things which hopefully show that SHIPSALE 22 has become very clear and as you have also seen, very much structured, but hopefully also clarifies a few things that in practice over the last years have raised some problems or discussions, arguments, or even worse. So as you will have seen, we have clearly separated these two scenarios into two separate clauses with their own regime, and avoiding a big clause with all kinds of sub-clauses that are interlinked and so on. But for the contract, we and the parties usually decide what they want to do, either an underwater inspection, which is the more popular scenario and decision, or a dry dock. So this is being decided and ticked in and clarified in box 17, where you just insert either 8 or 9, subject to your decision. But also, unlike in the past, there's no need to delete the other alternative just because you have chosen number 8, for example. And probably even more importantly, you should not delete this, because if you can just quickly move to 9A, 9A stipulates when the dry dock clause should come into effect. And this means it can stand there undeleted, and it should stay there undeleted. To be clear, because in certain situations, even if you have chosen the underwater inspection, situations could arise which may need the dry dock inspection become effective. Now going back to 8 now, just highlight a few things. In 8A, we have no option for the buyers to decide whether or not he wants to do an underwater inspection. It is clearly an automatic obligation from the seller to make the ship available for this inspection, because we thought that any decent buyer would probably know at the time of negotiations or latest when signing the MOA that he wants to do this. So why not making it clear from the beginning? So again, something which gives a little bit more clarity and avoidance of discussions. Then we have something in subclause D, the place of delivery. Again, we want to be clearer here. There was in previous forms some hidden hint where it was assumed that this place where the dry underwater inspection should take place should be the place of delivery. But now it's clear it shall be at the place of delivery, and only in cases where the class requires to go to a different place because the circumstances may not be suitable for an underwater inspection, or the parties agree otherwise, it can be at a different place. And a different place could also be subject to agreement, of course, maybe the last port before the ship arrives at the place of delivery, or even combine the inspection from the buyers of the ship together with an underwater inspection, which also happens occasionally. Then in subclause E, just a small remark that we have suggested, I would say, that a representative, meaning one of the buyers, shall be attending the underwater inspection, can be one of the two that are on board maybe already after the deposit has been lodged, or it can be someone, some other surveyor from the buyer's side. But that avoids the misunderstandings which came up when the buyers sent 3, 4 people to join this underwater inspection, which of course is not good. G. Okay. Now this is something I have to go back a little bit in history because it's now finally clear, as I think, as we think in all respects. You remember that in previous forms, there was no clear instruction when could the sellers tender the notice of readiness. Before the underwater inspection, because the ship is ready and it was just an option from the buyers to do this, or only after a successful underwater inspection. So this has been revised in the meantime, as you know. So the sellers can only tender the notice of readiness once the underwater inspection has been done successfully. But what has not been discussed and stipulated is what would be the consequences if the buyers, for any reasons, whatever, fail to arrange this underwater inspection timely. Once the vessel has arrived at the place of the underwater inspection. And that, in turn, leaves the seller unable to tender the notice of readiness. So there was a little remark that the inspection should not be, that the inspection should be arranged without undue delay, as you remember. But we thought in the worst case that wouldn't cover the seller's position if, for example, the buyers simply fail to do this. Now, this has now been made clear in that in the subclauses 1 and 2, the buyers who in the end are responsible for arranging the underwater inspection, as we see in subclause C, which is not on screen right now, but you can see it there. So the buyers are responsible for arranging the underwater inspection. But if there is a delay, they do this there are two scenarios. Either the underwater inspection has commenced but was not completed. So then within 2 days, this failure clause, let's say, would come into effect. Or in the worst case for the buyers, would lead to a loss of the right to do this underwater inspection if within the 2 days that we have suggested for that delay, the underwater inspection has not even commenced. So again, we think this gives SHIPSALE a much clearer position for the sellers, and it puts also the buyers under a certain pressure and obligation to make sure that the arrangements for the underwater inspection are made without time loss and delaying the delivery. So then some small remarks on J. So I have to say before can you mark the I to J, to K? So you remember that there was the situation introduced that you have the underwater inspection, the class finds a damage. The damage does not necessarily have to be repaired before next dry docking. That was introduced because the market suggested it, and it should avoid delays on the delivery process and give both parties the possibility to agree on a deduction of the purchase price equivalent to the costs for these repairs. And in order to achieve that amount, you can either try to mutually agree on it, or if that fails, you have to obtain quotes from shipyards nearby. So that was the scenario that we have been, that there is in the industry, and I think it's being used quite often in practice if there's damage found. Now in I to K, what we have done is we widened the possibilities for the parties to obtain these quotes and added repair facilities, in addition to shipyards, because we know not every place of delivery has a shipyard, but maybe it has a repair facility, so that gives both parties a little bit more, a wider choice of getting these quotes. And we have given both parties 3 banking days to obtain these quotes in case they cannot agree otherwise. Now for the same part in K, we have brought in a new idea in that we say, okay, if there is a class damage found and the parties decide to find agreement on the deduction of the purchase price, the canceling date should automatically be extended by three banking days, which are the 3 banking days that we have given the parties to obtain the quotes, to be in a fair situation in case the delivery or the underwater inspection is so very close to the canceling date. So that we see in K. Good. Then we move to clause 9. There's only 2 small remarks I want to make. I mean, I already mentioned in clause 9a, when does this clause come into effect? So this should stay. Nothing in this clause should be, or the clause should not be deleted just because you are choosing 8 as the first choice. In D, we have extended the canceling date for the case that the ship needs to find a dry dock elsewhere than the place of delivery to 21 days. And in I, as we thought also important, we have no more no, I shouldn't say no more, but the buyers have no right or option to request the sellers to have the tail shaft drawn prior to delivery. Only, it remains valid only for the situation that the class wants that. And as we think, again, a clearer and more independent decision made by class and avoids possible delays if and when the buyers come up with such a request very late in the delivery process. So, and then I was asked to say a little bit about the clause 14, but there's not very much really. Grant has already pointed that out. Just to say in general that following the logic and the concept of the whole sale form of the ship sale 22, we have tried to, or we have not tried, we have put together all the money relevant items that one or the other party has to pay into one clause rather than finding it distributed over the contract. So this is what clause 14 follows. And the other little remark I wanted to make is on C, where we have again tried to more comprehensively describe the situation that whatever deductions there could be on the way from the funds being sent on the way to the seller's account, that the buyers have to compensate same, or the paying party has to compensate those deductions which occur on the way during the transmittance. So that's all from my side. Thank you very much for your attention.
Christoph, just before you sit down. No, this is serious. No, we just had a question from one of our online participants, and it was just to do with the underwater inspection clause. And I think it's probably appropriate time to ask you now, but under clause 8G Roman 2, the question is the cancelling date extended by the amount of days over the 2 days allowed, or is it the total amount of time taken?
Say again,
Is the cancelling date extended by the amount of days over the 2 days allowed, or is it the total amount of time taken? Is it added to that?
Yeah, that's a good question. Thank you very much. Matt, I would think it should be additional time to be completed. It should be adding up after the 2 days. Because if we say shall be extended by the additional time taken for the underwater inspection to be completed, and it has already commenced, then I would think that you have the 2 days, you find out it's not working out, and then it's from day 3, the cancelling date shall be extended until it's completed.
Lovely, thank you, Christoph. And I noticed a nod from the jury as well, so that's good. And the good news is we're receiving lots of questions online, so we're going to be keeping you busy after Francis finishes, I think so. Thank you very much.
Okay, thank you, Christoph. Right, I've got a little goodies bag for you and some novelties in this SHIPSALE 22 that you can't find in sale form. So I'm going to talk a little bit about the deposit clause, then I'll come on to sanctions and anti-corruption, and then I'll finish with something about electronic signatures, which is a bit flavor of the day, I think. But starting off with the deposit clause, Casper, if you could just highlight 5C. There we go. As you can see, there is a new concept there. We're talking about the deposit holding agreement, something which wasn't in sale form 2012. And the deposit holding agreement is something which has become standard. So we felt it was necessary to actually provide for this in this sale form. And what it does, it basically provides the basis upon which the deposit is received, held, and released. For example, it will deal with the fees to be paid, when the interest has to be returned and to whom it has to be returned, and when the deposit is released, for example, upon presentation of a PDA or an unappealable final arbitration award. So that's one of the new things that we've put in here, which is basically just following standard procedures that already exist. So if we can now move down a little bit, because now I'm going to talk a little bit about what we thought was something that we had to introduce for the buyers, sort of a safety net for the buyers. That's good. That's excellent. Yep. The safety net that we've introduced for the buyers is basically if there's a problem with pushing the money through the banking system, something might go wrong, which is beyond the buyer's control. And we thought that we might have to give buyers some respite to make sure that he isn't penalized too much under clause 18. Clause 18 is the draconian situation that can occur if the buyer is in breach of paying the deposit. He would then have to pay compensation to the sellers. So to blunt that a little bit, we've introduced what we will call the disruptive banking event, which is defined in the clause. And I think you can see there a failure in the banking system, an oversight or error on the part of the buyer's bank, or a review by the deposit holder's bank. And all of these are defined as a disruptive banking event. And what happens then if something happens in the system that the buyers weren't responsible for, then the buyers get 2 extra banking days within which to remit the deposit. So that's a really nice feature for the buyers. I think it was something that we thought was necessary just to blunt the effects of clause 18. So I think we can move on now to sanctions, which is clause 21, if I'm not mistaken. Yeah. So I'm going to take these two together, sanctions and anti-corruption. Sanctions and anti-corruption, well, to start off with, the sanctions clause is a version or an amended version of the already existing BIMCO clauses, sanctions clauses for time charters and voyage charters 2020. So a little plug there for those 2 clauses for those wishing to insert those into their charter parties. But talking about sale and purchase here, we've slightly amended those clauses to apply to a sale and purchase agreement. And as you can see, there are some definitions: sanctioned activity, sanctioned authority, which is quite wide. It's not restricted to United Nations, European Union, the US, as you sometimes see. It's a broader definition. And it's a very objective test that is applied in terms of breaching sanctions. And there's a warranty there. The parties warrant that they are not a sanctioned party acting as a principal and not as an agent or trustee or nominee of any person as a sanctioned party. And then you have, what are the effects of a breach of this clause? Well, then there's the right to terminate and or claim damages from the breach. Moving on then to anti-corruption. Very, very simple clause. It just provides for an indemnity if there's a breach of any anti-corruption legislation, and also touches on the point that if one of the parties is in breach of anti-corruption legislation and causes the other party to be in breach of anti-corruption legislation, then there's the option to terminate or claim damages resulting from the breach of those regulations. What you don't see here is money laundering provisions. We've kept those out. Those will normally be dealt with separately by the parties in conjunction with their legal advisors and the banks. So we didn't want to over-legislate, and that's the reason why AML is not in this form. So now we can move on to the end, to electronic signatures, the flavor of the day. Everybody likes an electronic signature. I do, anyway. It makes my life a lot easier. So I don't have to move. I can sit behind my computer and just sort of sign documents. It's very, very easy. And it's actually something that was used a lot during the lockdowns that we've had over the last couple of years. It's been easy just to sit and, behind your computer or wherever you are, all over the world, and sign a document electronically. We've dealt with this here. It basically means that you can sign something, this document electronically, and it doesn't affect the validity. What we have done, we've also I think it's in C, yes, in C, we've carved out yes, thank you, Casper, for highlighting that. In C there, we've provided for a carve out. If, for example, your bill of sale, the registering authority for a bill of sale requires you to have an original handwritten signature, then we've provided for this carve out here in C, 27C. So that's all I really wanted to say. I mean, these are just sort of new things that we've introduced, some novelties, clauses which make it a lot more modern, especially the electronic signature clause. It's just something that makes it really up to date and a very easy thing to use. And Casper was mentioning to me earlier, sign is something that's widely used. You also have this public key encryption technology, which you probably use to fill in your tax forms. That's what I use anyway when I fill in my tax form. So it's all very, very easy nowadays. And this basically just means that everything now can be done electronically and doesn't affect the validity. It's accepted as an electronically signed document is accepted as being perfectly valid. So I think that's me done. And I think now we're going to move on to questions and answers. Grant, is that where we are? Are there any questions for me or for the panel?
Yeah, in actual fact, I've got a quick question.
You got a quick
straight
question?
before you sort of go back to your seat.
Yeah.
It was just that you're talking about the anti-technicality provision.
Yeah.
And the question is, why does it only apply to the deposit and not to the balance of the sale and purchase price?
Yeah, I think that's a very, very good question. We did actually look at that question when we drafted this form, and we thought it was appropriate to have this anti-technicality applied to the deposit and not to the balance of the purchase price. The reason for that is when you're getting towards the end of the sale process, more towards delivery, parties are more focused on getting things right. And the KYC has already been done. KYC is something that might hold up a payment. That's already been tested and done when opening the deposit. And secondly, another reason why we didn't apply it to, or wouldn't apply it to the balance of the purchase price, is because potentially you could have massive exposure for the seller in that his asset is there waiting to be delivered to the buyer, and it could be sitting there for maybe 10 days. If you add up all the days, the banking days, the 3 banking days, then the 2 extra days that we've granted for the deposit, you could have the asset sitting there for quite some time and expose the sellers to considerable losses, which you don't have obviously when you are opening the deposit. The sale has just started. So that's basically the answer to that question. I hope that's a satisfactory answer. Yep.
I'm entirely satisfied, Francis.
Yeah, are you
Thank you very much.
satisfied?
Yeah, I'm
Well,
satisfied.
if you
That's good.
are,
Yeah, that's good.
okay.
So if you like to take a
So
seat
can I
now.
sit down?
So please sit down. Yeah. So thank you very much to our panel. Do you want to come on and say a few words? I'm obviously forgotten you're going to mention something. Oh, exactly. Beg your pardon. Yeah. So what Matt's going to do for us now, before we go into the Q&A, a very important part is what is not in the contract. And obviously this is things we discussed as well. And it was part of the consultation process. People came out with suggestions of things. So there are things we have not included, and Matt is going to explain what those things are and why they aren't included.
Thanks, Grant. So just to go back to this consultation process. So as Grant said, 200 plus entities giving comments, 800 plus comments. We did go through them all, and we went through them all online on Zoom. So it was a fairly long process. The test that you broadly apply, I think is as follows, that first of all, you're looking at the comments, and the most important thing is, are they of general application, sufficiently general that it will be appropriate for a standard form? A lot of comments come in with people who've had particular issues or particular problems that they would like to be resolved, but they're just simply not general enough to really merit going into a standard form. I think the second criteria in a way that we have to look at is, are they reflective of market? And that's a difficult one. You know, the standard forms are not there to try and change market. They're trying to, it's a balancing exercise between reflecting market, whatever market is, and there's obviously geographical differences, and different sectors have different practices. So you've got to draw a line, and you don't always get it right for every sector because you can't. And the last way we sort of looked at it was, is it balanced? Do we think that it creates a balanced position? So you take those three broad criteria and others and apply those to the questions. And on the whole, the good news was that the vast majority of comments we had considered and we had taken a view, rightly or wrongly. So we didn't really get much by way of surprise for things that we hadn't at least considered and taken a view on. I think there were two themes which did promote a lot of discussion and a lot of consideration, and where we'd received a fair amount of comments for things that should be included in the contract, but which we ultimately decided not to put in SHIPSALE 22. The first, obviously, you have to bear in mind that this discussion was going on in the midst of COVID-19, and therefore there was a lot of requests for whether we should be including either a COVID-19 type clause or more broadly a force majeure provision. Ultimately, we decided that we would not include such a provision, a COVID-19 provision. We'd been, obviously, all of us that are working in the industry had been, you know, busy drafting clauses, and the answer is that they were quite specific and they were quite tailored. And when you're producing a standard form, you've got to be careful about something which is ultimately going to cause more difficulties than it solves, because the next event, force majeure event, may not have the same implications and consequences. And this was even more true when it came to the force majeure clause. For those of us that work with shipbuilding contracts, we're very familiar with force majeure and how it works. That is obviously a long-term relationship which is fully appropriate for there to be force majeure events. We felt that in the context of ship sale and purchase, we had dealt with individual force majeure events, total loss, anti-technicality, the disruptive banking event, and even to some extent, the fact that the seller, while if it fails to deliver, but not through its own negligence, the other side, the buyer, will be able to terminate, but not claim further compensation. So there is already baked into SHIPSALE 22 specific force majeure type events and consequences. But it was felt that in the context of second-hand ship sales, a general force majeure clause would cause more problems than it would solve, because it could be open to abuse. So that was the decision that was made, rightly or wrongly, for that theme. The second theme that we have spent a long time thinking about, because a lot of people have pushed very hard for its inclusion, was a clause dealing with recycling. And the common requests here was that the clause should deal with either or both the fact that the vessel is being sold for on trading and should not be sold, and the buyer will not take it away and scrap it or recycle it. Or secondly, if they were to do so within the given time, that there should be a clause essentially saying that recycling has got to be done in a green, responsible and Hong Kong convention compliant manner. Now, again, we did think about this and there was a lot of discussion on it, but we eventually came down on the side that we would not include this clause. The reasons for it, I think, were twofold. The first is that we applied the test of how generally applicable is this likely to be? And the answer, of course, is that in most cases, vast majority of cases, of course, the buyer is buying for trading the vessel after taking delivery. The second thing is, what do you put in the clause? because a lot of people were very keen to have a clause, but were less specific as to what should go in it. And we were concerned that actually just simply having a clause that says, you buyer will not recycle this vessel or send it for scrap, but will trade it, in a sense, gives a false sense of security for a seller who really needs to be doing its due diligence in circumstances where, to the reasonable person looking from the outside, it was perfectly obvious that that vessel was of a type and an age and a condition that might be ready for recycling or scrapping. So we came down on the side that for the printed terms, for the general terms, it was not appropriate to put in the recycling or non-recycling clause. However, mindful that this is something which is obviously of import to certain aspects of the market, it is something that BIMCO have been looking at. And Francis, if you're there, do you want to have a few words of what the BIMCO position is in terms of recycling, a recycling clause?
Yeah, thanks, Matt. And yeah, there was, when we put this to the industry, there were, I think we had, the most comments were on this point. I think we had about 20 to 30 comments, if I'm not mistaken, commenting on whether there should be something in relation to recycling. And just to give you the BIMCO's, the BIMCO official view at the moment is that what we would like to do is to try and accommodate some of those people who were calling for this kind of clause, is to develop a standalone clause that parties can actually insert in their sale contracts. So we've established a subcommittee. It's already been composed, and we're just waiting to have our first meeting on that. And hopefully in the very near future that will happen. And so you will have something hopefully in your drawer which you can just pull out and then use for your sale and purchase transactions. So that's work in progress. So we're dealing with it. And that's the latest news, hot off the press for you here. Matt, is there anything else for you? I'm looking at Grant.
Thank you very much for looking at me.
Yeah.
Yeah, thank you, Francis. If you'd like to take your seat again, we now move on to the Q&A bit. Now, I've actually received quite a lot of questions from our online participants. This is not a competition, but I am opening the floor to those of you seated in front of me. If you have any questions for the panel, this is now your opportunity. Otherwise, I'll just start reading them off my list. So is there anyone? We've got microphones and everything, so you don't have to shout. Sorry, they are kind of seem blinded by the light, but yeah, we're going to get a microphone here.
Good morning, and thank you for a very interesting presentation. I'm Rosie Goncor from law firm Hill Dickinson. And first, the question I have is probably aimed to Christoph, but of course, if everyone else can commit as well. So my question is in relation to underwater inspection. And I just wanted to ask, because we've recently been looking into the interpretation of the word conditions, and whether conditions would, sort of be limited to atmosphere conditions like, water, wind, swell, and so on, or whether it can be interpreted more widely. And also in this regard, the question which arose recently is, for example, what happens if at the delivery port, which is usually nominated by the sellers within the specific delivery range, what happens if there are no divers available? And for example, of course, we understand that it's the buyer's obligation to arrange the diving inspection, but of course, they cannot do that themselves. They have to have qualified team. Usually it's quite a large team that is required. And, there is this tension as to what, the class surveyor can say about the conditions if there are no divers available. Thank you.
Thank you very much for the question. For the conditions, I would think it is in a way fairly simple because it's fully in the hands of the classification society to make that decision. If they feel the place is unsafe in the way that you described it or unsuitable in terms of weather, water quality, things like that, then they have the sort of right to tell the parties you have to bring the ship elsewhere. And that is also regulated how this will go. And okay.
So you would say
if
that,
this was the answer to your question.
yes, so for example, if there are no divers available.
Yeah, that's the second part.
Uh-huh.
So the condition is clear, I hope.
I see.
I mean, my reply. So on the divers, I think again, the buyers have to arrange for this and have to make sure that a diver is available. And if it is not, what would you say, Matt?
Because
just trying to-
I can just develop. So we had the situation, actually it was a case which we had and which settled, but that was in relation to the period during COVID, where effectively no one could travel to the port, and there were just simply no divers available who could attend the inspection. And the vessel was tendered for delivery very, very close to the cancelling date. And the question arose then, which, you know, what happens to the deposit mainly, of course, and to the sale in question.
Okay, I mean, the contract, the basis situation is the buyers have to arrange for it. How they do it is their job. If the situations come into a region that you described, I think it's a matter of going aside from the contract, because these circumstances probably cannot be covered in all detail. And then the buyer should approach the seller. I mean, that's not a contract thing. That's let's say, a consequence of the situation when it arises. And they have to find a mutual agreement how to overcome that. But here's Matt.
Thank you.
No, I'm not disagreeing with Christoph at all. I think it's a fair point, and it in some ways goes back to the point I was just making about where you draw the line between force majeure and simply one side having to take a risk. Who should bear the risk? Here, you are right. There is a risk. The buyer is responsible. It's their risk that they can't get the diver there at that place at that time. But when you balance it against having a clause in there that then starts to go into force majeure, and you look and say, well, actually, how many times is this a problem? Against, if you try to create some sort of force majeure situation, that could be abused or used all the time and create uncertainty. So I think it's really, as you say, it's not perfect, but you've got to fall one side of the line, and this gives certainty of contract, even though occasionally it may create a difficult result.
Thank you.
And maybe just to add a little bit, the new clause that we put in at least covers a little bit the buyer's obligations in the delay, I would think, because it says, okay, you have to arrange it. If the ship comes there and for whatever reasons that you described, you are unable to bring a diver there, it could be a little bit going into this area.
Thank you.
Lovely. Thank you very much indeed for your question. While we're on clause 8, the underwater inspection, there is another question here. And the question is, there's no reference to class notes or memoranda affecting vessels class. Is that on purpose?
So the answer to this one is that if you go to, Casper, could you go to the interpretation clause in clause 1? And at the bottom of clause 1, sorry, my glasses. If you see that at C, so rather than where with some of the other forms where they mention it each time there is a reference to conditions and recommendations, here we've housed it in the interpretation clause, and as you'll see, for any requirement of this agreement, that certificates are to be without conditional recommendation, notes or memorandum in the reports shall not be taken into account. So it's there, it's in the interpretation clause.
Thanks, Matt. Good answer. Any other questions from our audience here? Yes, sir.
Thank you. Magne Andersen, Nordisk Defence Club. I think one of the main features of SHIPSALE 22 is the guarantee provision, which is a goodie in Francis's goodie bag. But I have to admit, I wonder whether and how these provisions will actually fly. Because as a matter of English law, there is nothing about consideration, and this is certainly not a deed. I might be making too much out of it, but still I would like to pose that as a question. And as a matter of civil law, at least, there is nothing about what kind of a guarantee this is. Is it an on-demand guarantee, or is it a guarantee whereby you have to exhaust your claim towards the debtor before you can go to the guarantor? And also, I thought it would have been a good idea to tie in the guarantor to the same choice of law and jurisdiction as between the parties, so that you know where to sue the guarantor. And then probably a more novel point, but it's the placing of the signature box, particularly the one in respect of the guarantor, but maybe also in respect of the other parties. I would have thought it would make sense to put it at the end of the agreement, particularly given the fact that there is nothing between part 1 and 2 on top of the signatory boxes that they say or confirm that they're bound by both part 1 and part 2.
Thank you very much, Magda. And I have to say as well that we've been asked this question online as well about the guarantees as well. So we're really interested to hear the answer on that one.
No, thanks for those questions. There are quite a few bits to that, so I'll try and make sure I cover each one. I think that the starting point is that, as I said, I think when I was going through the contract, in most cases where there is going to be a guarantee, certainly in the transactions I work on, the guarantee is actually contained in a separate instrument. So I think this, what I would expect to see in SHIPSALE 22 is that the guarantor, whether it's for the buyer or the seller or both, will be identified in the contract, but not necessarily a signatory to it. We did discuss then whether we should leave it at that, but as we know, there are circumstances where, using other forms, the guarantee is simply referred to, whether it's a parent or somebody else, and it simply says, and these obligations will be guaranteed by X, and the parties, in a sense, leave the law to fall where it may, but they prefer to use this short form where it's a parent. But as I say, in most cases where you want to get it right, the questions that you raise as to whether it's going to be an on-demand guarantee or something less, that needs to be stipulated. The other thing we have to remember, of course, is, as we saw when we looked at the law and arbitration provision, is that it may not always be English law. You mentioned, of course, that, you know, civil law as well. This is another, obviously, challenge one has when you're trying to produce a standard form that will work across all of the different sectors in the shipping market, but also has to not be only applicable for one system of law. So one has to be very careful when one goes down that route to ensure that you are sometimes lacking specificity in order to ensure that you're going to at least make the document usable, whichever of those systems of law you use. The question I'm not going to answer, because I don't know the answer, is about the placement of the signatures. I don't know if you take that. I mean, do we?
The placement. I think that's a good one for you, Francis, isn't it? I don't mind answering it, but I mean, the fact is, as you know, Magda, this is, you know, we're introducing a box layout into a ship sale agreement. We haven't had that before. That is BIMCO standard format and layout. So that is normally where we would put the signature box rather than at the end of the agreement. So, yeah. So, okay. All right. So we're getting towards the end of our session now. I know there's lots of questions come in online. What I will say to everyone that is online, I'll come back in a second there, is that we will send written answers to you. Well, I say we, I mean these gentlemen here. I will pass them the questions and they will answer them. So you will get a reply to the questions you raised. There's just too many for us to deal with in the amount of time that we've got at the moment. I'm just going to quickly put one of the online questions to you before we come back to you. And apparently there are other ship sale agreement forms available in the marketplace. It's not just ship sale. So I have to make a reference to it. In the sale form 2012, it excludes reference to the sale of goods, or it excludes the Sale of Goods Act 1979. Does ship sale? And if not, why not?
If memory serves, the sale form 2012 does not expressly exclude, does not make reference to the Sale of Goods Act, precisely for the reason I just gave, that it may, that would be far too specific because that's an English law issue. Rather, it actually excludes the implied statutory terms, whichever statute applies. We do, in our entire agreement clause, I'm sorry, I'm forgetting the numbers now, 26, 25, I'm so sorry. So if you see there in, there we go, yeah, 25C. In fact, what we've done here, we've gone belt and braces, following this is an English case law issue, following certain cases in English law, which say that if you want to exclude the Sale of Goods Act, you have to do so in no uncertain terms. And therefore, we have said that if any term and crucially condition, representation statement, etc., capable of being implied into this agreement by any applicable custom statute. So there's the statute that would get you your Sale of Goods Act is excluded, then it will be excluded. So that's where we do it. So we've not only done the statute, which would cover the Sale of Goods Act, but we've broadened it out to customs as well.
Lovely, thank you very much indeed, Matt. One very last quick question from the audience there, please. Can we got a microphone? Oh, yeah.
Thank you. I just have a quick question about sanctions clause, if I may, which is probably topical at the moment. According to the current sanction clause, can you please explain what would happen to the deposit if one of the parties are sanctioned? And a second question would be, do I understand correctly that the current sanction clause does not really cover the situation where sort of sectoral sanctions are imposed? Because at the moment, specifically, we see quite a few disputes where none of the parties are sanctioned. However, there is a prohibition of sale of certain vessels. Thank you.
Yeah, two very good questions, in fact. The answer to the first question is about what we actually did, and that's something I actually forgot to mention, is that if you see what happens if there's a breach of the clause, there's a termination right and a claim for damages. A thread throughout the SHIPSALE 22 is that we refer back to clauses 18 and 19, where provision is made, what happens if there's a termination, then the deposit is released, blah, blah, blah. That we haven't done here, specifically for the reason that you've just given, because there may be problems with the release of the deposit if there's a breach of sanctions. That money may be blocked. So that's why we didn't. So the remedy here is termination and the right to claim damages. We don't mention anything about the deposit. Whilst we do in other clauses where there's a termination right, we do then mention what happens to the deposit, if you can follow what I mean. So that's why I've expressly left it out here. Not necessarily. That will have to be dealt with, through the courts maybe, because the deposit will probably be blocked, and then how can you get that deposit released? It will probably have to go through the courts. No. No, I don't think it would be an automatic.
Apologies. Yes, what I mean is that we currently see quite a few bespoke clauses where the parties deal with a refund of a deposit, for example. So sometimes, if one party is sanctioned, the deposit is basically being refunded, and then damages are claimed as a separate sort of item. Sometimes the deposit is appropriated by unsanctioned party.
It could be, but the banks will still have to approve that release. And so there may be instances where the banks say, oh, this is sanctioned, and the money remains where it is until it's resolved through the courts. So that may be an issue with regard to the deposit, that it may not automatically be released, even if the parties have agreed separately that the unaffected party would get the deposit returned.
Mm.
I think that's the answer to your question. But
thank you.
And your second question was about you were talking about sectoral.
Yes, for example, if none of the parties are subject to sanctions, however, the main object of the agreement, sale of a particular vessel, is being prohibited by relevant authorities.
I think it would come under the sanctioned activity definition. I think because it's a very objective test, sort of sanctioned activity means any service, carriage, trade, or voyage subject to sanctions imposed. That would automatically trigger the clause.
Thank you.
Yeah.
Thank you.
But if you want to discuss afterwards the bit about the deposit, feel free.
Thank you so much. Thank you.
Lovely. Thank you very much, Francis. Just before we wrap up here, you've all got one of these on your seats. This is a takeaway. It's a freebie. We're not charging you money for it. Please feel free, if you've got a friend, to take a second copy. If you've got two friends, take two copies. There's a pile of them over there. We want to spread the word about this. We think it's a great document. This is a very good way to introduce the document and explain the background thinking to it all. I should have mentioned at the start that this whole proceeding has been recorded and will be available online. So again, you could watch it back if you particularly want to. I'm now going to invite George Eddings from the London Shipping Law Centre just to say a few closing words for us. So George, if you'd like to come up.
Thank you, Grant, and good morning, everyone. As a director of the LSLC, I want to say how delighted we are to partner with BIMCO in putting on this presentation. The LSLC put together something like 2 or 3 lectures a month throughout the year. And without a shadow of a doubt, I want to say that this is one of the most important lectures that we've been associated with. So I just wanted to say 2 things. One is to thank BIMCO, and secondly, to thank the panel for such an informative explanation. It's been such an informative morning. So thank you very much. So I'm sure, can I invite the audience to, I'll invite you to put your hands together and thank the panel. I think it's been superb. Thank you very much indeed.
Thank you very much indeed, George, and thank you also to the London Shipping Law Centre for helping us prepare all of this as well. It's been a very valued partnership. Francis, you'd like to say a few words as well?
Yeah, just to close off, thanks very much for those kind words for us. It's been a pleasure to be able to explain a little bit about SHIPSALE to you today. And this is the part of the show where I have to really pump you up, because this is a promotion for SHIPSALE 22. It's very important that you use the new form, and I've just jotted down a few reasons why. Well, it's been 10 years since there was SAIL Form 2012. That's 10 years where a lot of things have changed. And so this is an update and a facelift. So that's one of the main reasons why you should be using this form. It's very user-friendly. If you look at the box format, you could even use the box format as a format for a recap even. So it makes it all very, very easy. The list of documents has been taken out of the body. The list of excluded items has been taken out of the body. So it's all very easy to use and easy to amend. The form also follows the normal sequence of events, the normal progression of a sale process. So that's also very, very important and very nice. And also it's a modernized document. It includes sanctions and anti-corruption clauses, as we've just discussed, things that parties usually add on to SAIL Form 2012. Now they're already in there. So it will cut down the time for negotiation. Although I do appreciate that some parties do have their boilerplate sanctions and anti-corruption clauses, which they may want to impose. But anyway, I think the inclusion of a sanctions and anti-corruption clause makes our lives a lot easier. And also just to mention that there's mention made of modernizations, things that have come up very recently during the lockdown, during COVID. I think COVID has had a lot of negatives, but it's also had a lot of positives. It's meant that we've done our business, or we're doing our business in a different way. And so there's a reference to remote closing, something you don't have in 2012. And also what I discussed, what I mentioned to you earlier, electronic signatures, making it very, very easy to sign. So to conclude, I commend this document to all of you. I would say go out and sell the message. It's very, very important, because I think this will be the standard going forward. And what's nice about it, it still retains a lot of the familiarity that about sale and purchase that you had with 2012. A lot of that familiarity is still there. A lot of the clauses are very similar, but at the same time, they've been amended and fine-tuned to bring it up to date and make it very much more user-friendly. So that's all I wanted to say, and just thank my colleagues as well here. Thank Grant, thank Casper, thank the Secretariat of BIMCO for all the work they've done. And I think it was quite a glitzy sort of stage to be on and be able to present this to you. And thanks for your attendance, and hopefully we might see each other in the future at another seminar, or I don't know, perhaps not, and wish you all a very nice day. Thank you very much. Thanks.